And what's alleged is, and it's the last clause, maybe two clauses, it says a place specifically described in order, to wit, the residence of a protected individual, namely Mark, and it should say Nick Williams, but it says Mark Williams. So in order to meet this charging document, it would have to be that gentleman's residence. He does not reside there, as by his own representation.
Let's break it down. The whole charge hinges on a guy supposedly being somewhere he wasn't allowed. But here's the kicker. The person he's ordered to avoid doesn't even live there anymore. You can already see this case starting to unravel.
Ready for a nap. Like a big meal and a nap. And then Fortnite. Yeah, I'm in La La Land. There you go.
I don't know how I often slow down progress, Judge, but somehow, at least I'm consistent.
Yeah.
So.
Morning, Mr. Bio. You speak English, right?
Yes.
Okay. All right, Mr. Bio, you're charged initially as of, it looks like November 7th, you picked up an assault of a family member. I see now that you've picked up a new case. As of November 30th, you've picked up a violation of a bond condition or protective order. I don't know which.
Here's where it gets messy. We're about to hear what sparked the newest violation charge. Pay close attention who actually lit the fuse and who just got pulled into it.
Knows that you picked up a violation case. You're facing now another year in jail and or a $4,000 fine. I haven't done probable cause, so we're going to do that. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one.
Officers were dispatched to a residence in Harris County, Texas in response to a disturbance. The complainant stated that he was locked out of his residence by his ex-wife's new boyfriend. The complainant went to the residence because his ex-wife had called them and stated that she was going to work. When the complainant asked who would be watching their children, the ex-wife said friends. The complainant then heard defendant's voice in the background and went over to the apartment. The complaining witness is the same complainant.
You said he heard whose voice?
The complainant heard the defendant's voice in the background. I think that the complainant believes that the defendant would be watching his and his ex-wife's children, and that's why he went. The complainant is the same complainant from pending AFM, and the apartment address where the defendant was staying is listed on a signed order of protection.
How bad of an assault were we talking in the original case? What happened?
I think it was
Punch,
something
slap.
in the face with
Once, twice, thrice?
2 to 3 times.
Okay.
Give some background on that I think they're also still working through.
On the assault case, we issued a protective order, I would imagine.
Yes, not going to talk to that judge.
And we ordered him, did we order him not to have contact with this person?
Yes. And that's on the basis of the charge. And so if we go into the state's file information, which is also the basis of the allegation that he violated, well, I imagine you're hearing both kind of in conjunction, the new charge PC, but also considering the questions of bail with respect to the first charge as well.
Of course.
What's been alleged in the new information is that Mr. Bio went to the residence of the CW, Mr. McWilliams. As of the date when we first appeared in court, the representation was made by both Mr. McWilliams, and then today the representation was made by the ex-wife of Mr. McWilliams, who is the dating partner of Mr. Bio. So he is dating this gentleman's ex-wife. But she has confirmed to both of us that McWilliams has moved out of that residence as of the date of the first alleged assault. And McWilliams has told them they have been unable to reach McWilliams as of recently.
Now comes the legal twist. If McWills doesn't even live there, the entire basis for a new charge could collapse. Legally, that's like trying to bake a cake without flour. The charge just won't stick.
In the recall information, McWilliams confirms, "I moved out that day and do not live at the address that's at issue in this BPO case." If you look at the filed information in that BPO case, it's a necessary ingredient of that allegation that McWilliams lived at that address. It specifically says it in the last line.
You're saying in the protective order?
Yes, no, not protective orders. In the violation of protective order case, if you look at the state's filed information in that case, you will see the last line is, to wit, he was at the complainant's residence, but Mr. McWilliams doesn't actually live there. He moved out. Actually, was not on the leash.
You're still not supposed to have contact with this person.
He's not. He didn't have contact with him. What happens is he's at a place that is not McWilliams' address, and then McWilliams, angry that he's there, still wanting to control his ex-wife, comes over there and busts the windows. And so that is
What's the window of
his ex-wife's house where Mr. Biden.
what's the ex-wife's name?
Shannon.
Shannon. Okay, so
We both spoke to Shannon a few minutes ago.
and Shannon has how many kids with Mr. Bio? Or do they have kids or no? So whose kids are they? McWilliams?
Williams and Shannon's children.
Okay.
I think there's two.
So what's alleged in the newly filed charging document is that Mr. Bio went to the residence of McWilliams, which there's no PC to believe in. He did not.
Here's a question for you. Should protective orders be updated once someone moves out? Or does that just cause more confusion and wrongful charges? Let me know your take in the comments.
Of McWilliams. He went to Shannon's residence. McWilliams does not live there, stopped living there, and the state can't meet the information. And so there's no PC on, my argument, Judge, is that there's no PC that the state or the officer.
So in our case, in the assault case, the protective order says that he's not supposed to go to this Spring Cypress, the apartment in Spring Cypress, right?
Well, contemplating that that's McWilliams' address.
Is that his address? Yes or no?
That is no longer his address.
Okay.
When that was filed, I imagine that was the original apartment, but on the
A lot of
day,
times they never update it. They just put the original apartment where it happened at, and they always assume that it's this, just
so that's no longer the address. Mr. McWilliams moved out of that address on the day of the incident. And he told me he moved out. I believe that Shannon is the only name on the lease.
for the violation case. Where is he alleged to have gone to?
He went to the address that's listed in the original motor. So he went to the
Spring Cypress.
Right.
Okay. But what he's saying is that this person no longer lives there.
Well, that's what McWilliams told the state, and that's what Shannon has told both the state and myself, and that is what our full understanding is. Now, I know that address is listed in the protective order, but what's contemplated by the protective order is don't go to a place where McWilliams lives, and McWilliams is not living at the Spring Center.
The problem is that we also have this address there because he could always go back.
Well,
He may not live there. Maybe he lives there partially. Maybe he comes and goes. So he is also as a preventative measure so that we don't want you to actually or accidentally bump into this person. And that's why we have this there, is that he did live there at one time. Perhaps he may go back. He left an article of clothing. He left pizza there, or whatever it may be.
Well, what's really happening is he wants to go back and continue harassing his ex-wife. And that is what Shannon has represented, I think, to both of them. I wasn't privy to their phone calls, certainly what was represented to me. And
What do you want?
I want no PC to be found on the violation of the protective order charge, because an element of that offense that's been alleged is that Mr. Bio went to the residence of McWilliams. McWilliams does not live there. It's not his residence. So there's no PC to believe that that element is met.
What do you think?
Judge, I don't know on this matter. I will say, Judge, in the charging instrument, the defendant it does say, he's not allowed to intentionally or knowingly go to a place specifically described in the order. The address in the order, that's where he was staying. But in terms of
The address.
Now it's the so-called victim showing up and smashing windows. The whole story just flipped. Is this really a violation or straight-up harassment from the other side?
Who was staying?
the defendant was staying at the address in the order.
In this
The
particular
original
order.
Moab, Spring Center.
Okay.
The defendant was staying there. But I will say in terms of PC, I'm going to different on this matter.
And may I just read that little blurb of the information that I think is important for the court to hear? May I take a, yes. Chief and Field Officer, go ahead. So,
Do we still have a problem with him trying to communicate, though?
no, he didn't want to have any communication. This gentleman comes over to the place and starts busting the windows.
I will say the complainant came to the place where the defendant was staying. He initiated the contact with the situation.
And what's alleged is,
So the address issue won't matter moving forward. But here's the real problem. How are courts supposed to enforce protective orders when the facts are this murky? And who's actually being protected here?
clause, maybe two clauses, it says, place specifically described in order, to wit, the residence of a protected individual, namely Mark, and it should say Nick Williams, but it says Mark Williams. So, in order to meet this charging document, it would have to be that gentleman's residence. He does not reside there, as by his own representation to the state. And so, I'd ask that, and I know it's a unique situation.
How do we go forward, though? If I find no PC, how do we go forward?
Well, goes back out on bond while we prepare our defense to the initial charge of assault, which I think they've seen quite a bit by way of background about Mr. McWilliams.
How do we know that this isn't going to happen again?
I will say, I'm not sure where Mr. Byer will be staying after he were to get out on bond, but the witness, Shannon, she is no longer living in her apartment as of tomorrow. So that address will no longer, it won't belong to any of them as of this.
Do we do a no contact with both?
I don't know if we would do no contact with the witness, with Shannon.
Shannon?
But I would ask no contact with Mr. McWilliams.
You are now in a relationship with Shannon, right?
But yes,
So
I'm instructed and just let me answer for him, Judge. But he is in a relationship with Shannon, that's right. And he moved here from Hawaii to be with Shannon, and the ex-husband takes issue with it. And the ex-husband has a very violent history with Shannon. And so, long term, we think there'll be issues with case one. But I understand that that's not really we're not there yet. I think the question is what to do if he is out. I do think, obviously, no contact whatsoever in any form, shape at all with Mr. McWilliams is appropriate. And that is what existed. Unfortunately, the state can't even reach McWilliams because he doesn't have a phone number that is even good.
have you run an NCIC check on this McWilliams guy?
We can see his in-county criminal history, but I can run it when you check on.
Do you see? I mean,
I don't want to be incorrect, but I think he's got violent history with Shannon. But maybe Judge, when you get through my age, it's hard to remember all the details. But I think I recall that. Maybe I'm mistaken. I don't want to represent something inaccurate.
you have inherited a dangerous situation. And Mr. Bio, you need to be very careful. You know, if you're in a relationship with someone and they have another person that's in their life that's like this, you could be the bearer of bad times. So you need to be very careful. You're in a very volatile situation. So you need to be careful going forward because it really could just could go out of control. You may need to get a protective order yourself. You know, it's very possible that you may need to get a protective order. So just be careful. You're in good hands. You ever have any issues, just reach out to Brian. We can always help you out as well. I'll find no PC on the violation of protective order. But just be careful because there are a lot of vindictive people in this life that will they'll try to make your life a living hell. And you being on bond in this case, they can do that. They can say, hey man, he's doing this to me, he's threatening me, he's doing that. And if an officer doesn't know any better and they come up and they see that have this open assault, they may never take your word. They may never even speak to you. They'll just put you in county. So you gotta be careful. You know, you're in good hands. We'll help you out for as much as we can. Okay? Okay, so I'll find no PC on the on the violation case. And I'm not going to revoke your bond from the original assault case, Mr. Bio, but you got to be careful, man. You know?
Judge, I think we should also have him give his updated address to pretrial with the property as well.
Okay. And I think that's probably somehow make a notation in everywhere so that we know where Shannon lives. You don't have an address for McWilliams, so I don't know how we're going to handle
Well,
that.
I think the protective order does say any address where McWilliams does reside. So whether or not, it would be a notice question, but we know not to go anywhere where he lives.
I think the issue is whether this other person's going to now be, okay.
You understand?
If you have any questions, just be careful. Life's too short to live either in a 6x9 box or be 6 feet under because you got other people that have just be careful. All right. Good luck. Good luck, Mr. Mayo.